What do you get when you mix your First Amendment rights with a computer and a 12-year-old child? You get a hot debate on cyberbullying, which is taking the lives of thousands of minors each year and is raging uninhibited by the law. The First Amendment, as defined by the United States Constitution, written in 1787, states that the Congress shall make no laws respecting the establishment of a religion or prohibiting the free exercise thereof, abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and petition the government for a redress of grievances. While those are a lot of freedoms to defend, I'd like to zero in on the one in particular that states no laws shall be made to abridge our freedom of speech. If a more concise interpretation of the First Amendment would assist in grasping how the government could possibly control our voices, I believe Voltaire put it this way: I disapprove of what you say, but I will defend to the death your right to say it. Now let me lay out a second set of facts that might muddy the waters on this relatively clear, inalienable right that our founding fathers gave to us to steward. 4,500 minors die of suicide each year as a direct result of cyberbullying. Cyberbullying, according to stopbullying.gov, is defined as when a child, preteen, or teen is tormented, threatened, harassed, humiliated, embarrassed, or otherwise targeted by another preteen, teen, or adult on social media platforms. The repercussions of cyberbullying are so severe that there have been thousands of websites that have been implemented to cyberbullying-specific suicide hotlines, such as the Cornell Law Institute, the American Association of School Counselors, even industries such as the Cartoon Network and Facebook, all have hotlines to stem the 1 in 10 minors per year who attempt suicide as a direct result of some form of cyberbullying. And this is according to the Cyberbullying Hotline. While these hotlines address the daily virtual abuses of some minors' experiences, some cyberbullying cases make national headlines. And while many stand by our First Amendment rights, I believe it's time that we start prosecuting in the 21st century for the abuses of the First Amendment, because unfortunately there are far too many examples to build such a case. So, are cyberbullies protected by the First Amendment rights? Before we make any knee-jerk conclusions, consider the following cases. As reported in the Huffington Post back in 2012, Georgia middle school student Alex Boston reported to school officials and school police that she was being bullied on the social media platform Facebook. She was promptly told that there was nothing they could do about it, since, technically, the grievances were occurring off campus. At the age of 14 and under some serious duress, Alex and her family filed a lawsuit against the classmates perpetrating the bullying. They did this by creating a fake Facebook profile, defaming Alex so intensely and regularly that soon Alex became physically threatened at school. The courts would not take the case, determining that it was the perpetrator's right to say what they will because of freedom of speech. The fact that justice was not found in the courts left Alex feeling hurt. The events did conclude with some apologies from the bullies, a donation to charity, and eventually legal proceedings had the infamous Facebook profile deleted. The damage, however, follows Alex Boston to this day. Take the example of Tracy Norman of Florida, who was the mother of 12-year-old Rebecca before Rebecca threw herself off the roof of a factory after being viciously and persistently bullied online and at school. Certain posts even encouraged her to end her life. Sharing her plight with school officials only stopped the physical bullying at school while the virtual bullying continued. Tracy, her mother, filed the lawsuit against the school for not protecting her daughter further, as well as wrongful death lawsuits against the two teens who she said virtually tortured her daughter. Neither suits progressed, leaving many unjustifiable actions permissible by the law. While these are just a couple of examples, I'm sure you can find others, there is a pattern that emerges. According to the Pew Research Institute, 95% of teens between the ages of 12 and 17 all have social media accounts. And this is a survey taken back from 2012. Experts estimate that the average age of social media users today is 10 years old. With an increase in social media usage of all platforms, whether it's sharing a picture on Instagram, a video on Snapchat, or words on Facebook, paired with the inexperience and the insensitivities of adolescents, whose prefrontal cortexes of reason and behavioral choices are not completely developed, you're going to have an increased correlation in cyberbullying. Another pattern that we can address is the sexual demographic, whereas females are 2 times more likely to experience cyberbullying. According to NoBullying.com, boys are into more physical aggression, which makes virtual bullying less of a threat, while females tend to use social media as an emotional tactic, hiding behind profiles and computer screens. The No Bullying website also cites a study done by the University of Miami that the subtle, methodical spread of vicious claims and images normalizes cyberbullying, making the response and the effects insincere. That's not to say that one gender takes precedence over another, but it does bring to light the safe zone that the virtual world creates for bullies to enact their harassment on a much larger scale. These statistics have been measured since instant messaging and social connectivity began on the internet in the not-so-recent past. Legislation has been passed between various branches of government to address the potential criminality of cyberbullying. However, we're not united in this effort. So how did cyberbullying become acceptable when it comes to our freedom of speech? I believe one legal battle conveniently summarizes the gray area between justice and the protection of rights. In 2011, a 15-year-old boy from Albany County, New York, pled guilty to creating a Facebook page that contained graphic sexual comments and images of classmates from his high school in order to elicit harm to them. The Albany court system then passed a law for the school banning electronic communication intended to harass, annoy, threaten, or otherwise inflict emotional harm on another person. Unfortunately, the Court of Appeals struck down the law as they determined that it violated the First Amendment. Because of this, all charges against the 15-year-old were dropped and the case faded. The discourse, however, on the interconnectedness of our First Amendment rights and cyberbullying remained. Dozens of states took heed of the ruling in New York and began to craft criminal sanctions for cyberbullying, and many more are considering it. Despite the specific court ruling in New York, cyberbullying laws are unconstitutional. Justin Patchen, the co-chair of the Cyberbullying Research Center, participates in drafting new legislation. In a post-trial interview, he expressed optimism, stating that the trick is to pass a cyberbullying law that is comprehensive in its coverage of bullying while still passing constitutional muster. It's a tall order. The debate is heated on both sides of a blurry line. Some argue that children shouldn't participate in social media. Of course, that's more of a parenting argument which cannot be so broadly applied. Others argue that it's the right of anyone using social media to say, or type rather, whatever it is that they want, and it is up to the reader to discern what the appropriate response or lack thereof should be. However, it's too late to turn back the clock. Children are already using social media, and children are already dying as a result of cyberbullying. These are abuses of our First Amendment rights, something our founding fathers could never have accounted for when they wrote them. While we cannot federally regulate how to raise our children to be kind to one another, we can bring justice to First Amendment abuses that lead to death. Didn't anyone ever tell these bullies that if you have nothing nice to say, don't say anything at all? On debate.org, over 67% of those who have chimed in on this conversation side with the bullies, saying practically what Voltaire did. Like it or not, these bullies do have a right to say whatever they like. I argue that the lack of punishment for libel and slander in cases that lead to death of a child is a severe abuse of the First Amendment, and the amendment itself cannot be used as an excuse. While we legally obey the letter of the law, I believe that the spirit of the law never intended for words that kill to be overlooked by the justice system. The drafting of legislation not to censor, but to set precedents for punishing the abuse of our First Amendment right ought to be seriously considered by local, state, and federal courts. When we tell our children, preteens, teens, and even adults that you can harass, blackmail, publicly embarrass, and malign each other without reprimand, then we shouldn't be surprised when bullies of all ages hide behind doctor profiles within the safety of their own homes. Conversely, if they were doing those things in reality, they would be caught and reprimanded. Sticks and stones and words kill. And just as someone who throws a stick or stone is liable for the damages caused, so they must also be accountable for the words that they utter.